Good evening, friends. I am using the term evening, good evening, because I am recording this in the evening. In today evening, we are going to deal with a topic, the offer. As you are aware, the term offer is a term which is used under English law, and in Indian law, we use the term proposal. But both are same, proposal, offer. Indian law, it is proposal, and English law, it is offer. Now, before we start with the offer, let's recollect we have seen in the earlier videos. What is a contract? A contract is an agreement enforceable by law. What is an agreement? An agreement is two set of promises forming consideration to each other. And what is a promise? A promise is a proposal accepted by the person to whom it is made. So this is what we have seen in the last day's class. So the thing is that every contract starts with a proposal, or in English law, an offer. So it's the start of a contract. That is the proposal. Now let's see what is a proposal. I'll go back to the example. That is, I make an offer to Parvati who's there in front of me. Parvati, will you buy? Parvati, will you sell your watch to me for 5,000 rupees? Parvati, will you sell your watch to me for 5,000 rupees? Now, this is a proposal. I am making this proposal to Parvati. Here, Parvati is called by the name a proposee. That is a person to whom the proposal is made. And I am the proposer, the person who proposes. And in English law, we can say that in English law, it becomes the offerer and the offering. Indian law, the proposer and the proposer. Now, when I make this offer or proposal to Parvati, she says, "Sir, I am willing to sell my watch to you for 5,000 rupees. Then what happens? Then she has accepted my proposal. Now, when she accepts my proposal, it becomes a promise. That is, when an offer is accepted by the person to whom it is made, it becomes a promise. Similarly, when a proposal is accepted by the person to whom it is made, it becomes a promise. So, proposal accepted becomes a promise. Here, when it becomes a promise, I'll be the promiser and Parvati will be the promiser. This is the evolution of a proposal into, or change of a proposal into a promise. That is, when it is accepted, it becomes a promise, and two set of promises becomes a contract, which we have seen in last week's class. Or the last video. Those who have not gone through it, please go to my earlier video. Now, in this class, we are going to study what are the main rules with regard to offer, or what are the main rules with regard to proposal. The main rules are: 1. The proposal should be accepted by the person to whom it is made. First rule. Proposal should be accepted by the person to whom it is made. The corollary is that for a proposal to be accepted, it should be communicated to the person to whom it is made. That is the corollary, which I'll explain with the case law later. The second rule is that a proposal has to be made with the intention to create legal obligation. A proposal is to be made with the intention to create legal obligation. So we'll count it again. First one, proposal should be made with, a proposal should be communicated to the proposee, or proposal can be accepted only by the person to whom it is made. That is the first rule. Two corollaries. One corollary plus one rule. The second thing is that a proposal should be made with the intention to create a legal obligation. Third rule is that a proposal should not be vague. It should not be vague. It should be clear. It should be definite. The fourth rule is that a proposal is different from an invitation to offer. A proposal is different from an invitation to offer. That is the fourth rule. And fifthly, we have to study about general offer, specific offer, and standing offer. These are three related terms. So these are the 4-5 main main rules with regard to offer. If you can go through all these rules, then the chapter offer is almost over. Then you have only small, short questions from this area, like the tend, or else you can have standing offer, cross offer, counter offer. Some small, short questions are there. If that is also covered, you can't expect anything else to come from the chapter offer. So, having said what are the main rules with regard to offer, let's start to study one by one. The first thing is, the first point, which I've stated earlier, is that an offer can be accepted only by the person to whom it is made. I say, Parvati, will you sell your watch to me for 5,000 rupees? This is an offer made to Parvati. It cannot be accepted by her twin sister Padmavati. It cannot be accepted by her friend Revati, who is sitting nearby. It can only be accepted by Parvati. As a corollary of this particular rule, that an offer should be offer can be accepted only by the person to whom it is made. One corollary is that only after an offer is communicated to the offeree, or a proposal is communicated to the proposee, can she or he accept the proposal. That is another rule of it. To explain this concept, let's study a very classic case, Lalman versus Gauri Dutt. Lalman, Lalman versus Gauri Dutt. Very important case, usually asked for the examinations. പല പ്രാവശ്യം ചോദിച്ചിട്ടുള്ളതാണ്. 2 വർഷത്തെ ക്വസ്റ്റ്യൻ പേപ്പർ എടുത്താൽ 1 വർഷമെങ്കിലും ഈ ചോദ്യം പലപ്പോഴും വരാറുണ്ട്. Let's see what is the case. It's a case of a master and a servant. And the rule is that an offer has to be communicated to the offeree. And an acceptance made without the communication of the offer is invalid. The offer അറിയാതെ ഒരാൾക്കും ഒരു acceptance നടത്താൻ പറ്റില്ല. അങ്ങനെയുള്ള acceptanceന് വാലിഡിറ്റിയും ഉണ്ടാവില്ല. That is, an offer can be accepted only by a person to whom it is made, and to a person who is communicated, to whom it is communicated. This is being elaborated in this case. This rule is being elaborated in this case. Now let's see what is Lalman versus Gaurida. In Lalman versus Gaurida, it's a story of a master and a servant. See, a master's nephew was missing. He ran away somewhere. He went missing. The master's nephew went missing. Now, what did the master do? The master said, he first of all sent his servant to find out the child. So he asked the servant, you go find out where he is, get him as early as possible back home. So he sent his servant. Let it be X. So he sent X. After sending X or servant, master made an announcement that if someone finds out the child and bring it back to him, he will pay him a reward, say 50 rupees. For the sake of it, we put it as 50 rupees. So if someone brings back my nephew, I'll pay him an amount of 50 rupees. The servant X, who had gone earlier, before this announcement was made, he went looking for the child and found the child. Brought the child back. On the way, someone said that, oh, see, your master has promised 50 rupees for bringing back the child. The servant was very happy. He came back to his master and said, Master, I found out your nephew. Please give me the 50 rupees reward. And the master said, no, I will not give you 50 rupees. You can go somewhere else. So he said, I am not going to pay you anything. The servant was agitated. There was an offer of 50 rupees to get back the child. He's bought the child back. And in the subsequent case, the contention of the master was, I had promised 50 rupees, but this was not communicated to the servant before he found out the child. So what happened? The servant went as a part of his duty and found out the child. The offer that for bringing back the child, you will get the 50 rupees was not communicated by the master to the servant. So the court held that the servant cannot claim the money. What is the rule there? The rule is that an offer can be accepted only by the person to whom it is made. A corollary, the offer should be communicated to the offeree, and only if it is communicated to the offeree can he accept it. So that is the first rule with regard to offer. That is, offer can be accepted only by the person to whom it is made. The second rule, what is that? An offer should be made with an intention to create legal obligation. An offer should be made with an intention to create a legal obligation. What does it mean? See, we make so many agreements. I see a friend, I say him, you come Sunday, you come to my house, my wife is a good cook, we will fill you with lots of biryani and ice creams and things like that. You come. I agree to give you biryani. Next Sunday he is there in my house. He says that I have accepted your agreement, fill me with biryani. Or else you take another example. A husband, when he is very affectionate to the wife, one fine night, tells her, darling, tomorrow I'll fill you, or I will what do you call, immerse you in a cask of gold or whatever it is. I'll give you 100 sovereigns or whatever it is. Alladate parnja swarnathil mooda. Or I will fill you with gold. I don't know how to say it in English. So next morning the wife wakes up and says that I have agreed to what you offered yesterday. Please fill me in gold. Poor husband. He is that contract bind. So the thing is that you make so many offers, you make so many agreements for the sake of it. These are not agreements made with the intention to create a legal obligation. It's not that serious. A contract to be valid, an offer to be valid, a proposal to be valid, it should be made with the intention to create a legal obligation. It should be that serious. Not simple passing statements like you get a pass or you get a first class, I'll get a scooter. That's what you usually say to your son or daughter. You pass the examination, I'll get you a platinum necklace. These are all things which we say normally. But they are not agreements or offers made with the intention to create a legal obligation. So this thing or this particular rule can be illustrated with a classic example. Now that is the case of Balfour versus Balfour, which happened in England. There was a husband and a wife in England. The husband got a job in Ceylon, that is the modern Sri Lanka. It is an early case. So when he got a job in Sri Lanka, he was not in very good terms with his wife, in the sense he was not in very good terms, but the poor woman was unaware of it. He wanted to escape somehow from her. So he made an offer. See, darling, I'm going to Sri Lanka. It's a place full of, what do you call, it's a very ugly place, very nasty place. You don't have to come along with me. You be happy in England. You stay happy in England. I'll just go there. I have to struggle there. So you be in England. And after reaching Ceylon, I will say, send you an MO. Say 30 pounds a week. Or the 100 pounds a month. And the poor wife thought, oh, it's okay. And she said, I will stay back in England. You go to Ceylon. She was okay. Now this guy, after making the offer, went to Ceylon, and after reaching Ceylon, nothing was heard of him. Nothing was heard of him. He was not sending money or even writing letter to the poor wife. She got upset. She waited for some time because that is the only money which is available to her. After some time, she filed a case. Her claim was, my husband had promised me 40 pounds or 100 pounds a month. And after going there is no idea of what he is doing there. No letter, no money. So this is an agreement and he has violated that agreement. And therefore, I have to get that promised money. When it reached the court went through the nature of the contract and said that this is not an agreement made with the intention to create a legal obligation. It was just a passing statement made by the husband to escape from the wife. I'll pay you, send you something. But there was no binding agreement. There was no formal offer. There was no formal acceptance. So this is another rule. The rule is that an agreement should be made with the intention to create a legal obligation. So that is an important case with regard to what we call an agreement should be made with the intention to create a legal obligation. Now the third point is that an offer should not be vague. An offer should be definite. A vague offer is when you make an offer which is not very clear. You don't clarify what exactly is the object on which you are making a offer. I'll buy that for 50 rupees. And I can buy this for 200 rupees. No, it is not specified what is that and what is this. One may think this is a hat, another may think that is a watch. So unless you specify what is the nature of the agreement, for what you are making that offer, the offer is not valid. The offer should be specific. It should not be vague. It should be definite. There was a case called Foley's case. Here, in this case, a man sold a horse, and it was stated that the horse was sold, and it was stated that if the horse is lucky, that days you have races and all these things. If the horse is lucky, I will give you 3 pounds more. This was the statement which was made. Now the question is, how can you determine whether a horse is lucky? Whether it means that the horse will win 2 out of 3 races, or the horse wins all the 3 races, or the horse wins alternate races. You see, when you say that something to be very lucky, it's not very definite. So this is an example where you are making an offer which is vague. So an agreement or an offer which is vague is invalid, and an agreement created out of such a vague offer is also invalid. So that is the third point. Now, fourth point. What is the fourth point? Fourth point is, an offer is different from an invitation to offer. See, an offer is different from an invitation to offer. Now, what do you mean by an invitation to offer? Invitation to offer are certain activity which resembles an offer, but it's not an offer. You may see it seems to be an offer. We may think that it is an offer. We usually get a feeling that it is offer. But that is not an offer in the real sense. Such an offer, such an activity is called by the name an invitation to offer, or an invitation to treat, or something like that. Invitation to offer. For example, a display of a goods in a shop. See, we take an illustration or an example. In a shop, a coat is displayed. You have a artificial model in the shop wearing a coat. We have seen dummies in the showrooms of textile showrooms. There are dummies wearing beautiful dresses. So in a shop, a coat is being worn by a dummy, and it is written on the coat 5,000 rupees, rupees 5,000. When you pass by the shop, you have a look at the coat and you are interested. You feel like buying it. You go inside. You call the manager and say, "This here, 5,000 rupees. I'm paying you 5,000 rupees. Wrap up the coat. Then give it up." And the shopkeeper is saying, "Sorry sir, I'm not going to sell it." Then you say that you have offered me the coat for 5,000 rupees. I have accepted it and I paid the money and you are not giving me the coat. Why not? തുണിക്കടയിലെ പാവയിട്ടിരിക്കുന്ന ഒരു വസ്ത്രം നമ്മൾ ഇഷ്ടപ്പെട്ട പൈസ കൊടുത്തപ്പോഴ് ഒരു പറയാണ് അത് തരില്ല. Can they do that? They can do it. Why? They can do it because when goods are displayed in a shop, they are not offers. You may get a feeling that it is an offer, but it is not an offer. It is an invitation to offer. That when the shopkeeper put a coat, shows a coat in the shop with a price tag of 5,000 rupees, it is an invitation to offer. On seeing it, you go inside and pay 5,000 rupees, or you put 5,000 rupees on the manager, in front of the manager, then that is the offer. That is when you go and you say that you are willing to buy it. This is the offer. And this offer can be accepted by the manager or the shopkeeper or rejected. Had it been the other way around, it will be an offer, and when you go inside and say I'm buying it, it becomes an acceptance and there will be a contract. But it is not it. It's only an invitation to offer. There is a very famous case in this area, that is Harvey versus Fassi. I'll be dealing with the facts of the case at a later instance, because it comes in another topic also. So these are the main four rules with regard to offer. There is another rule which we will be dealing in the next video, because it is somewhat a big area, that is the difference between a specific general offer and also standing offer, tender, counter, cross imposed offer. So what we have seen today is, there are 4 principles. The 4 principles are, first of all, we have seen what is an offer, that is a proposal. That is the starting point of every agreement is the proposal, and only when the proposal is accepted, it becomes a promise and it becomes a agreement in the due course. Now, with regard to proposal, the rules are: proposal can be accepted only by the person to whom it is made. Rule number 1. Corollary: it has to be communicated. Secondly, a proposal should be made with the intention to create a legal obligation. Rule number 2. 3. What is rule number 3? A proposal should not be vague. And fourthly, we have seen that a proposal is different from an invitation to offer. It may resemble an offer, but it is different. It is an invitation to offer. So these are the first part of rules with regard to offer. As it is evening, here I may say that it is good time. Okay, thank you very much for the patient hearing. You go through the test, try to understand it by yourself. You have to continuously go through the matter, read it, get refreshed. So this is just an overview of the concept of offer or proposal. Thank you.